Right from the start, this judge is setting the stage for a serious felony case. Felonious assault second degree means the court is already dealing with a high-level violent offense. Pay attention here. This early setup usually hints at where the sentencing might go.
Thank you, Your Honor. Your Honor, we're here this afternoon in case kept in the state of Ohio. This is Alan Servar, case number 24-CR001179. We were last here on April 3rd, at which time the defendant entered a written and oral plea of guilty to one count of felonious assault, felony of the second degree, in violation of Revised Code Section 2903.11A1. The case was then referred for a pre-sentence report, an investigation, an updated psychological, and a victim impact statement. Those have been completed, and we are here today for purposes of sentencing. Defendant is present today with his counsel, Mr. Chad Mulkey.
Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. Your Honor, he's 50 years old. He's single. He has no children. I did see in his report, he confirmed that he did get an associate's degree in culinary arts, but that was a long time ago, and since then he had been working in construction and roofing, found that to be more to his liking. He'd like to get back into that line of work. Your Honor, he understands that he has...
Notice how the defense leans heavily on addiction history. In many cases, drug dependency becomes a major mitigating factor, but only if the defendant shows consistent efforts at recovery. The lawyer is trying to humanize him before the judge gets to the hard evidence.
Has to deal with the consequences of this case here. The serious injury occurred to his mother. There's no denying that. He knows that is what happened. Going back to his history, he has significant drug use going back to the age of 14 with marijuana, and then from there cocaine, and then heroin. Particularly opiates seems to be his drug of choice. Most recently, he acknowledges that he has a problem with those. He was trying to get off them, but that problem has not yet seemed to have been dealt with. So he would like treatment as part of his sentence, Your Honor. I'd explained to him the realistic nature of the charge and the consequences in terms of a prison sentence. He knows that may be in his future in light of the circumstances of this case, Your Honor. So we would just ask the court to consider a lower side of a prison sentence if the court deems that is appropriate, citing his lack of criminal history. He would like to someday, if possible, repair his relationship with his mother, get the treatment that he needs. And again, based on his age of being 50 and his lack of history, and then go from that to a felonious assault of his family member, it just seems that it was something that would not be repeated again, certainly not to not in any sort of a consistent pattern or anything like that, Your Honor. So,
what do you think? Should a defendant's past relationship with the victim reduce the sentence if the victim forgives them? Or should the violence itself outweigh all of that? Let me know in the comments. Judges often struggle with this exact question.
We would just ask the court to consider minimal incarceration time followed by appropriate treatment such as NeoCap, Your Honor. Thank you.
Thank you. Mr. Serrar, you have the right to address the court before you are sentenced. You can say anything you'd like. Is there anything you want to say at this time?
I've already spoke with my mom. She knows. She's already even told the detectives that this would never happen. I was going to the methadone clinic. This wasn't drug-induced. I was going to the methadone clinic. I was getting 140 milligrams of methadone, and I figured out a heavy narcotic. And I was flunking every drug test, and they didn't say anything for 8 months. So I had this one morning, I said, I'm not even doing the methadone anymore. Stopped cold turkey. Didn't sleep for 10 days. Mental police picked me up, running up and down the street. They took me to an intensive care mental hospital for 7 days, where the doctor even said I wasn't ready. This is all video evidence of me not sleeping. And then 2 days after I left the mental hospital, this happened. And even when I was at this jail, I'm on camera not sleeping. This wasn't drug-induced. This was from lack of sleep-induced. I would never, all the years I've been, I would never harm anybody, let alone my mom. And she even told the police that. She's like, she knows this isn't me. And I mean, I'm at a loss of words, I'm heartbroken. I mean, like I said, I mean, you've seen a lot of people here, Your Honor. You have high power perception. You'd have to make your own judgment, but I'm heartbroken over this.
Thank you. Mr. Mulkey, anything else you care to say?
No, Your Honor, not at this time. Thank you.
Ms. Linden for the State of Ohio.
Thank you, Your Honor. Your Honor, as I indicated in Chambers, the state is recommending a prison term. As I stated, there aren't many cases these days that when, because I've been doing this for as long as I have, that I actually look at a photo and gasp, and I did here. This is, and I know that the on-call prosecutor that was involved in this as well, similar reaction.
And here's where the case takes a dark and devastating turn. Prosecutors don't usually describe injuries in this much detail unless the photos are truly shocking. When a prosecutor says they gasped, that tells you the evidence is extreme.
It is horrific to see the injuries that this woman, who was 80 at the time, sustained. There's one thing to have a black eye, and there's another one to have a black eye that's so swollen and out that it almost looks like the eyes are bulging out. She had brain bleed. She had multiple broken bones as a result of this. And as I stated, when you listen to the 911 call, I know the defendant says he only hit her 4 times, but you hear 5 distinct thuds. He does talk about grabbing her, squeezing her, and taking her to the ground. And she remembers some part of it, and she remembers arguing with him. But looking at that, looking at the fact that she was in critical condition, she was intubated and she was in the hospital for so long, this is more than what I normally would see. And especially looking at the factors that we have to look at under 2912B, C, D, and E. She's 8 years old. Their relationship, it's his mother. She had serious injuries. So she had physical harm and psychological harm as a result of this. Looking at the fact that he doesn't really have much of a history, he does have the 2 prior OVIs and a drug case, but drugs seem to be a really significant issue for the defendant, and it doesn't seem as if even the treatment that he's had, if there are real mental health issues or if it's drug issues, he went in for treatment for St. Vincent Charity Hospital, didn't remain sober, did Signature Health, had medically assisted treatment there, didn't continue with the treatment. Through the methadone clinic, he did all right for a while, but then he refused medication and he's continued to use drugs throughout. And I don't remember the last time that I have seen something that says that there is a serious or severe disorder, opioid use disorder severe, stimulant use or use disorder severe, cannabis use disorder severe, and looking at that and looking at his history, he's been using drugs for a really long time, and it appears that his drug use causes him to have these types of episodes. And so in looking at protecting the victim in this manner and protecting the community at large, and looking at there's been some aggression that he's had within the jail. I know that a number of the incidents that he had were prior to him going to North Coast, but blaming stopping his medication, that's not what it is. There are serious issues that need to be addressed, and a prison term is definitely appropriate here. He does have 216 days of credit for time served, and we would ask for the forfeiture of all the marijuana, the foil package, the plastic bag, the metal can, the rolled cigarettes, rolling papers in the glass jar. But I just don't see any way that, based on the injuries here and based on the severity of this offense, that community control would be appropriate. Perhaps at some time at a later date when the defendant understands that there are serious consequences for his actions, maybe at that point in time, that's something to consider down the line, but not at this point in time. Thank you.
Competency evaluation that was earlier prepared in this case, the victim impact statement. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here in court by the defendant, his lawyer, the prosecutor, the recommendations from the parties. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911.
Right here, the judge is referencing Ohio's sentencing statutes. This is where legal reasoning takes over. Seriousness of harm, age of the victim, relationship to the offender, and the likelihood of reoffending. Watch closely, these factors directly guide the length of the prison term.
I've also considered the factors under 2912 that indicate the conduct is more or less serious, as well as recidivism factors. As far as the seriousness factors, the court finds the victim in this case suffered serious physical harm as well as psychological harm. And I recognize serious physical harm as an element of the offense, but the serious physical harm caused by the defendant and suffered by the victim in this case is much, much, much greater than what we normally see in a felonious assault case that deals with serious physical harm. I mean, serious physical harm is such a wide range of harm, quite frankly. You could have somebody that gets hit and has a scar. That's serious physical harm. The nature of the serious physical harm in this particular case is horrific, quite frankly. And then this injury and harm that's suffered by the victim is certainly exacerbated by her age, being 80 years of age. The relationship with the victim facilitates the offense. That makes it much more serious, being his own mother, 80-year-old mother that he did this to. There's no factors indicating it's less serious. As for recidivism factors, court will note that there's a couple of OVI convictions that's in on his record. There is a drug abuse problem. The defendant, it's gone untreated. A long drug abuse problem that's just gone untreated. As for factors indicating recidivism is less likely, the court finds the defendant doesn't have any prior convictions, aside from the OVIs, misdemeanor OVIs, there's nothing else. Law-abiding life. Basically his entire life, aside from the traffic stuff. This is a felony in the second degree. There's no way the court can make a finding at this point that factors indicating a defense is less serious outweigh the factors indicating it's more serious. Prison's consistent with the purposes and principles of sentencing. And this type of conduct and the harm caused by the defendant's conduct just can't be ignored. It can't be. Prison is consistent with the purposes and principles of sentencing. Defendant's not amenable to available community control sanctions. Therefore, will be the sentence of this court, the defendant serve an indefinite prison term of a minimum of 4 years, maximum of 6 years. He has credit for 216 days he's already served. Need to advise you upon your release from prison, you will be placed on post-release control for at least 18 months, could be up to 3 years. While in post-release control, if you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defendants ordered to pay all costs incurred in this action. Further need to advise you that the indefinite sentence that I just imposed, there is a presumption that you will be released after you have served the minimum sentence. That is not guaranteed, that based on your conduct in prison, but a presumption that you will be released after you've served the 4 years. Again, that could be rebutted by the Department of Rehabilitation and Correction. If at a hearing they are able to establish that while you are in prison, you basically didn't follow the rules. You committed institutional violations, you're not sufficiently rehabilitated, you still pose a threat to the community, toward others. If that determination is made, then you would not be released at the, and you have the right to be there at that hearing. If they can only do that if there's a hearing and you have the right to be there. But if they make that decision, then you would not be released. They would set another date for you to be released, and there'd be a presumption that you'd be released at that other date. That presumption can again be rebutted if again they proved that you are still committing violations, not behaving yourself, not rehabilitated, still pose a threat. Under no circumstances, however, can you be kept in beyond the maximum sentence. Even if you misbehave the whole time you're there, they have to release you after you've served.
So at this point, the judge is warning him about post-release consequences, basically what happens after prison if he slips up again. It's a powerful reminder that sentencing isn't just about prison time. It's about long-term accountability. What do you think of the final sentence? Fair or too lenient?
The maximum sentence. I further need to advise you that while you are in prison, you are entitled to earn good time credit. And there's a presumption, and if the prison officials, it's anywhere from 5 to 15%, if the prison officials find that you are entitled to that, they would notify the court. There's a presumption that I would have to approve that good time credit. You only get it if the court approves it. There's a presumption that it should be approved. If I wanted to disapprove it, you would have the right to have a hearing here in court before that could be disapproved. Otherwise, it would have to be approved. I think that covers everything. Is there anything else? Count 2 will be dismissed. Is there anything else for the record, Ms. Linden?
And just the forfeiture that we talked about, Your Honor, at the time of the change of plea.
It's all just drug paraphernalia and
Yes.
any type of drug paraphernalia and drugs will be forfeited.
Thank you, Your Honor.
Mr. Mulkey, anything else?
Your Honor, I didn't hear of it, so I'll just bring it up. Is there any restitution on this?
I don't believe. Let me check the victim impact statement again.
I was not advised of anything, but if there's something in the victim
I'll
impact
check right now.
statement.
I get several today, and I want to make sure I don't miss it. But no restitution. None that was provided in the victim impact statement, and nothing presented by the state.
No, Your Honor.
Thank you, Judge. Just double checking.
Okay, thank you.
All rise.